Good morning, everyone. Thank you for joining us this morning. My name is Sophia Steele, and I'm the Government Affairs Manager at Associated Builders and Contractors of Western Washington. Thank you for joining us for our webinar, The Top 10 Things You Need Going into the New Administration. I'd like to introduce today's presenter, Matt Lynch of Sebris Busto James, a management, labor, and employment firm located in Bellevue, Washington. I'd also like to mention Matt is our contract lawyer and is available to assist AUC members. Matt represents private and public sector employees in all aspects of labor relations and has negotiated hundreds of collective bargaining agreements, represented management and grievances in labor arbitrations, and handled many cases in front of the National Labor Relations Board. Now I'll hand it over to Matt and he'll get started with his presentation.
Well, good morning, everybody, and thanks so much for joining us this morning. It's 7:30, and I know it's the beginning of everybody's work day, and we'll try to be as efficient as possible. I appreciate the introduction, Sophia. There is a lot to cover, and I thought I would call the presentation the Biden Top 10. In other words, I'm trying to focus on what I think will be the 10 initiatives that our new president will undertake through the Department of Labor as well as the National Labor Relations Board. And I'll really be ordering them, I think, in terms of immediacy. In other words, things that will happen soon or frankly have already happened, as well as policy and statutory initiatives that I think we're likely to see at some point during the new administration. And I would guess based on the 2022 elections that are frankly a year and a half off or so, most of these initiatives will be undertaken, I think, during the first 2 years of President Biden's tenure. So what we're going to do is first we're going to talk about what his agenda is. What platform on labor issues did he run on? And then we're going to discuss, how we can effectuate that through putting new players in at both the NLRB and the U.S. Department of Labor. And as I mentioned just now, we'll focus initially on stuff that is already taking place and will take place, I think, in the very near term as well as longer term changes. And you'll see the little picture here is of a pendulum. I mean, it's very clear that this is how things operate in Washington, D.C. when it comes to labor issues, particularly at the National Labor Relations Board. We've had, as an employer, you've had 4 good years under the Trump NLRB. That will continue somewhat until this fall when the final, or not the final, but when the next Republican member of the NLRB, his term ends, and then there will be a new appointee, and it'll be a Democrat appointee by President Biden. That's when things will really start happening at the NLRB. But frankly, we'll see things are already happening now. So first off, what was the agenda that the president ran on? He had a platform called the Empower Workers platform. And I'm going to kind of quote from aspects of this platform so you get a sense of his ties to big labor, organized labor, and what his likely initiatives will be. For example, his platform states he wants to aggressively pursue employers from intentionally misclassifying employees as independent contractors. It's been a very hot issue. Who's a contractor? Who's an employee? Employees have more legal protections than contractors. He wants to enact laws that make worker misclassification a substantive violation of the law in all agencies, including tax laws, and increase penalties for employers who misclassify folks. He is going to, in his words, have an aggressive all-hands-on-deck enforcement effort not just with worker misclassification, but through OSHA safety standards, Department of Labor wage and hour matters, as well as the NLRB. And this was an initiative through the Obama years, which of course President Biden was part of. He is going to reinstitute kind of the collaboration and enforcement partnerships, he calls it, between the NLRB, the EEOC, Justice Department, unemployment. In other words, if the NLRB finds or thinks there might be a wage and hour violation, in the case it's handling, it will report the employer to the Department of Labor, potentially to a state enforcement agency such as Labor and Industries here in Washington, and then those agencies will take over that matter. So in other words, the eyes and ears of the government will be all over employers, at least for the next 4 years. He is going to be increasing the number of investigators. That's his mission, at least according to his platform, particularly at Labor and particularly at OSHA. He is going to, his purpose here, one of his purposes, and we'll talk about it in length, is to make it easier for employees to unionize. And you heard way back in 2010, 2011, the big debate over EFCA, right? Remember the old Employee Free Choice Act, which never became law. Well, the Obama NLRB created and implemented regulations, the so-called quickie election rules, which are actually, for the most part, still in place. The Trump NLRB did not manage to rewrite those regulations, except in certain narrow areas. Well, those are regulations which can be rewritten by the next administration's NLRB, for example. So Biden initiative here is to pass laws, get Congress to pass a law that encodes those election rules into law itself. And as you know, it's much, much harder to change a law, to change a statute such as the National Labor Relations Act, than it is to change regulations. And here's one of interest, not necessarily in the state of Washington, but with a lot of other states. His platform is to repeal or to pass federal law that makes it unlawful for states to have right to work laws. There are over 30 states in the country that have laws in place that make it unlawful for employers and unions to require employees to pay union dues. And as you know, back in the early 2010s, Wisconsin, Indiana, Ohio, for example, there was a real trend, frankly, in state legislatures passing right to work laws. So there was a bump up in that activity. Well, of course, that hurts unions in the pocketbooks. So the president has run on a platform saying that he wants federal law to supersede, to override state laws and make those state laws unlawful. And then finally, there's a little law out there, or a proposed law out there called the PRO Act. We're going to talk about the PRO Act. That could result in an upheaval in labor relations around the country. And this is an environment where something like the PRO Act, as we'll see later, very well might materialize now that we have a effective Senate majority in Congress. Other aspects, he's going to go after franchisors and employers. His platform is to hold the entity that holds the power over the workplace and hold them liable for workplace violations, wage and hour matters, union unfair labor practice charges, and the like. And these are the McDonald's cases, right, where under the Obama era NLRB, the NLRB was holding that the McDonald's Corporation was a joint employer to the franchisors and was liable for the unfair labor practices of the thousands of franchisors around the country, franchisees around the country. He wants to make sure that employees can strike without any real economic fallout. In other words, he wants to prohibit permanent replacements and strikes. He wants to allow secondary boycotts, and he wants to allow intermittent strikes. Intermittent strikes have been ruled unlawful by the NLRB for decades. Permanent replacements have been validated by the NLRB and by the Supreme Court for decades, going back 60 years, as well as secondary boycotts. And he would need to rewrite the National Labor Relations Act to make that happen. And then finally, he, in terms of independent contractors. President Biden ran on a platform of basically encoding, if you will, or putting into federal law California's ABC test for determining when someone is an independent contractor and when someone's an employee. And as you can imagine, California is the source of a lot of these Biden initiatives. And the ABC test, which by the way is not Associated Builders and Contractors, it is a moniker dubbed by the labor and employer community in California, makes it much, much more difficult for an employer to find or to consider somebody to be a contractor than an employee. Prevailing wage laws, he wants to strictly enforce per his platform. He wants to ensure that every federal investment in infrastructure and transportation projects or service jobs is covered by prevailing wage protections. Every federal investment in infrastructure and transportation. There are some carve-outs, as you know, some de minimis carve-outs, so he wants to broaden those prevailing wage laws, or he wants to broaden the prevailing wage commitment and requirement to every federal contract. Uber, DoorDash, he wants those workers to be able to unionize. He wants to eliminate non-compete clauses. He wants to strengthen OSHA laws and prohibit mandatory arbitration. So that's a little flavor of what he ran on. And it basically was a wish list from AFL-CIO. No surprise. I mean, he's their guy. Trump was the U.S. Chamber's guy. I mean, that's how the pendulum swings. And that's how the country rolls when it comes to, federal policy on labor and workplace matters. If you wanted to check out and read this stuff yourself, if you don't believe what I'm saying, you can go to his campaign website, which is on the screen in front of you. Before we kind of go into my predictions for what is going to be happening, let's take a very quick moment here to refresh ourselves that there's still a Democratic majority in the House. They lost Republican seats, but it's an odd situation in that you have Republicans picking up more seats that was not expected to happen. On the other hand, Democratic majority is being pushed by the elements of the hard left, the squad you've been hearing about, and so the Democratic majority in the House is being squeezed on the left as well as on the right by Republican members, but they still hold the keys, and they initiate laws, especially when it comes to revenue and taxation and whatnot. And then in the Senate, of course, there's a 50-50 split. The vice president will cast tie-breaking votes, so there's an effective Democratic majority. So we have Democrat in the White House, Democrats running both houses of Congress. That's normally a recipe for the Democrats, and if it was a Republican situation, for the Republicans to get whatever laws they wanted passed. It's going to be a little harder in the Senate, however, particularly on the labor front, because many of the initiatives that we just heard will impact various states in different ways. So there's much less, I think, of a likelihood that some of these initiatives are actually going to materialize or become law, meaning that the new president will be seeing what he can do through regulatory action of his agencies, chief among them the Department of Labor and the National Labor Relations Board, who are the new players at the board and at the DOL. So we have to understand that we are dealing now with agencies that are, I would have to say, not going to be employer friendly. And let's look at the Department of Labor. The current mayor of Boston, Marty Walsh, has been nominated to be Secretary of Labor. He was elected mayor of Boston in 2014. Before then, he was Secretary Treasurer of the Laborers Local in Boston and the head of the Building and Construction Trades Council in Boston. So he's a union guy. But he comes across very reasonable. His tenure in Boston had ups and downs for employers. But I think for those of you out there who have unions, unions ultimately, not all of them, but most unions ultimately are deal makers. And when you read about his two terms as mayor of Boston, there were efforts on his part to bring business into the community and to, basically broker deals between labor and between the business community, because, that was the way to get things done. So he's been nominated, and it's highly likely he's going to be confirmed. I have not heard any serious objections to his nomination coming from Republicans. You can see some of the things that he did in Boston. He signed an executive order requiring vendors to commit they won't engage in wage theft, and that's going to be one of the national pushes, I think, coming out of the Department of Labor. He, was pushing for the state to adopt a $15 minimum wage, which I believe occurred, but I need to double check that. He, created a city policy requiring a majority of workers on large construction projects to be residents of Boston or the communities where the work is being done, Boston in this case. So his confirmation will likely occur within the next several weeks. At the NLRB, there's much longer transition at the board than at the Department of Labor. And that's because the 5 members of the National Labor Relations Board are appointed by the president. It is tradition, it's not really the law, but it's tradition that the party in power at the White House can have a majority of the NLRB. So in this case, there ultimately will be 3 Democratic members and 2 Republican members. The White House also appoints the chairperson of the NLRB, and the White House appoints the general counsel of the NLRB. So there's nothing that the White House could do regarding the current membership of the board. There's 1 vacancy currently, so there are only 4 active members, meaning that the president can nominate the 5th at any time, requires Senate confirmation. But the other members' terms have not expired yet. So there will be a Republican majority of the board until August 27th of 2021, at which point member Emanuel's term ends, and then that creates a vacancy which the president will fill with an appointee, and that's when the majority will shift. So there won't be significant changes at the NLRB in terms of cutting edge case law, how the board decides other types of cases that aren't as interesting, if you will. There won't be much of a change. In fact, the Trump era will continue for about the next 7 or 8 months. Then things will start happening in September. Now, things are already kind of happening right now with the recent firing of the general counsel of the NLRB. The National Labor Relations Board's general counsel is a position created by the statute. It is basically the prosecutor, and the general counsel is the entity that decides what cases to put in front of the National Labor Relations Board, what theories to put forth. The general counsel can argue for a change of law, which then tees it up for the NLRB to change the law if the NLRB is of a mind to do so. The general counsel that President Trump appointed, his term was not set to end until this coming September, I believe it was. However, President Biden, within minutes of being sworn in, fired the Trump general counsel, Peter Robb, because organized labor wanted him to fire him. Robb was putting forth theories in front of the board that was giving the NLRB, with Trump appointees, an opportunity then to reverse Obama precedent and to go back to older case law or to create new case law. So the general counsel's position is actually very, very influential. It's not an advisor to the NLRB. It's actually the position that determines what cases are brought before the NLRB. And the general counsel does that through all the regions of the country. So Region 19, which is in Seattle, is really an office of the general counsel. And so that counsel, Peter Robb, was fired and was replaced by the regional director of Region 13 in Chicago on an interim basis. The legality of the firing is in question. So already there's been at least one case where the employer in that case, who was had just received an unfair labor practice charge filed by that particular region, is now challenging that charge on the basis that it was brought by general counsel with no authority to bring it because Peter Robb was fired illegally. So that issue is probably going to end up being litigated in court. I'm not aware of any suits yet being brought. It's still fairly recent phenomenon. But this was a way for the president to basically not wait to have a majority on the NLRB, but in fact to, if you will, staunch the flow of blood, coming from the Trump General Counsel and the Trump NLRB by putting a new General Counsel in place who's going to stop all Trump initiatives and make sure that over the next 8 months, the NLRB does not get any cases put in front of it that will give them an opportunity to pursue, Trump policies in federal labor law. The current, the new or the interim General Counsel is Peter Sung-Orr. As I said, he's from Chicago. He's already changing the enforcement direction of the General Counsel office. For example, the NLRB in another region in the country, the General Counsel, in another region of the country, filed a complaint against a union and an employer challenging the legality of neutrality agreements. And those are agreements that unions often try to coax employers into signing that says that, in exchange for us being nice to you for a certain period of time, you, employer, will agree not to, voice any opinion about unionization, and you'll let us come in and organize them without any kind of obstacles. Or as the interim has ordered the withdrawal of that complaint on the basis that it does not promote collective bargaining. It's not a very strong basis. Interestingly, there's another charge currently pending, a complaint currently pending, brought by the region, following a charge by AGC challenging community workforce arrangement or agreement that is required on State Route 520 projects. The Washington DOT signed community workforce agreements with various unions saying that any contractor the DOT uses and any subs the contractor uses will sign off on a community workforce agreement, which requires them to recognize the union and to have union labor, et cetera, et cetera. So very clearly, I expect that this complaint to be in the target or the sights of an interim General Counsel. We will wait to see what happens, but it's possible that the General Counsel will withdraw that complaint as well. Okay, so what are the top 10? The first is that, as I mentioned earlier with, for example, the appointment of Peter Sung-Orr, whose appointment is legally questionable, but at this point he's the interim General Counsel, and with other measures that the president is doing through executive orders, his initial actions are basically just to stop all Trump policies in their place. And he does this through executive orders. And here's a sampling of some of the workplace-related executive orders he signed within the first 2 weeks of his presidency. He signed an executive order or a memo freezing all approval of all rules passed by Trump that were not yet finalized. So, for example, the Department of Labor had issued a final rule on independent contractor status that created basically a two-tier or two-prong approach with 3 sub-tiers in it that would have made it much, much easier for individuals to be categorized as independent contractors. But that was not set to go into effect until March 8th because it was not in effect at the time that President Biden was sworn in. His executive order freezing any further processing of rules so that the agencies can go review them means that that new regulation on independent contractors by the Department of Labor will not go into effect, and it is dead. Sorry about that. Other executive orders and doing regulatory restrictions on federal agencies. So, more regulations will be coming out. And again, through the regulatory process, agencies can do a lot of longer term damage or, create longer term policies. With the National Labor Relations Board, there are not many substantive regulations that have been put out by the NLRB over the last 90 years. But with those regulations, once they're adopted and implemented and put into effect, then the only way to override them is either for a court to rule to invalidate the regulation or for the agency itself to propose new regulations on doing it, a much, much longer process. He's set out an executive order banning discrimination on the basis of gender identity or sexual orientation in the federal sector. Executive order promoting workplace safety amid the pandemic, directing OSHA to issue new workplace safety guidance within 2 weeks of 1/21, January 21st, meaning that we'll be getting some new OSHA regulations, which will then be scrutinized by labor and industry. We're sort of a WISHA state, right? We're not an OSHA state, but the states have to adopt regulations at least as, favorable, if you will, or at least as protective towards workers as the OSHA regulations. So those new workplace regulations will likely be adopted by LNI or even strengthened by LNI. There will be an executive order guaranteeing unemployment insurance for workers who refuse to work because of COVID-19. This is going to be an interesting one to follow because the wording of the executive order would suggest that all somebody has to do is say, I don't want to work because I might get the virus, and that immediately allows the individual then to qualify for unemployment benefits. He's directing the Department of Labor to study the $15 minimum wage and other measures that are in this particular executive order dealing with federal workplace protections in the federal sector. And then he has ordered the Department of Labor to end the payroll audit independent determination program, which was a program that would encourage employers to self-report wage and hour violations. If the employer would step forward and tell the Department of Labor, oops, we goofed, we misclassified somebody as an exempt administrative employee and that person's actually non-exempt, if the employer self-reported and provided back pay or wages that were owing to the individual, then the Department of Labor would effectively forgive. It was a safe harbor, if you will, and that from labor, at least labor's perspective, sort of emasculated the Department of Labor's wage and hour division. So they got rid of that, and we're back to good old enforcement by the wage and hour folks. Initiative number 2, increase minimum wage $15. I don't know if anybody here is surprised by that. They have limited impact, obviously, no real impact in the state of Washington. But this is going to be passed, and it'll probably be passed, I'm guessing, within the first 4 or 5 months once Congress shifts its attention from impeaching a former president to actually putting through the proposals and the initiatives by the new president. I'm not expecting any real meaningful opposition. In other words, it'll be a party line vote, but the Democrats have the votes, and so it's going to happen. The only issue, as I see it, will be whether it will happen immediately or whether it will be phased in. It'll likely be phased in. The Biden platform called for a $15 minimum wage by 2026. And depending on where the House is and how the Democrats are going to handle the squad and others, either they'll be passing the Biden platform proposal, or they may even come up with a more aggressive schedule. But again, state of Washington, no real impact because we're already marching and well above $15 minimum wage. Okay, number 3, very clearly there's going to be increased enforcement. Right now, for example, with OSHA, there's 761 inspectors, and Biden wants to double that. And there's a lot of consideration of maybe even going well above 1,500 inspectors. Now, again, they're inspecting, states. Those inspectors have impact in states that are OSHA states that have not adopted their own workplace safety rules, laws, rules, and regulations. As well as some employers who are subject to OSHA, regardless of what state you're in. However, I think it's fair to say that there will be discussion about if there's going to be a mandate that states increase their enforcement efforts, then there may be more federal dollars rolling into the state coffers to support additional inspectors. So I think what you guys are all looking forward to perhaps are having more L&I inspectors poking their noses around. The part and parcel of that is without really knowing details, the talk in DC is that they're also going to be trying to regulation increase penalties and as well as enforcement actions. And Again, if OSHA is going to have higher penalties, depending on where those particular penalties for particular violations are in relation to Washington penalties that Illinois has, it could be that we'll see an increase in penalties on the state level as well. Okay, I mentioned the ABC test for independent contractors. This is number 4. And the ABC test, which is likely to be adopted by the Department of Labor through regulation, states that a worker is going to be considered an employee. So the starting point is that everybody's an employee, and the burden will be on the employer to prove that the worker meets all of the following requirements. The person is free from the control and direction of the company in connection with the work, both under contract for the performance of such work and in fact. So in other words, there can be an agreement that says, hey, this contractor is not under our control, but that actually has to be the case. Facts have to show that. That itself is not too radical. That's been part of the standard that the IRS has used and the Department of Labor periodically over the years, as well as on the state level. But the key factor for employers, in number 1, is that you're really contracting with the individual for the outcome, for the product, for the service that's being performed, not on how the person does it, not how the individual achieves that outcome. So you don't control that, you just control what the final outcome is going to be, product, service, what have you. Number 2, employers will need to show that the worker performs work that's outside of the usual course of the company's business. So, for example, if you have an Uber driver and the person is driving for Uber, well, that's the company's business of Uber, right? Uber moves people from point A to point B. And I just heard on a Jeopardy question yesterday that Uber has had 10 billion rides so far. So an Uber driver is performing work that is inside the usual course of Uber's business. And that's the standard, is the person doing something that the business doesn't really exist to perform. So for example, if you have a law firm and you have an air conditioning problem, you're going to hire an HVAC contractor to come in and fix it. Well, that person's outside the usual course of the law firm's business. I'm not capable of repairing air conditioning systems. And then finally, number 3, the worker has to be customarily engaged in an independently established trade or occupation or business that's of the same nature as the type of work performed for the company. And the third one is really geared towards license, sort of position. So if you have, a chiropractor or an attorney or an engineer, and they are working in their own office or for their own company, it's an independently established trade or occupation, then that person would be considered a contractor. So those are 3 pretty strict requirements, particularly numbers 2 and 3. So if you're going to be hiring somebody to come in, working side by side with somebody, performing similar duties to one of your own employees, for example, then you are not really meeting question number 2 or point number 2, and therefore the person would be considered an employee. And if that's the case, you have to have federal withholdings, you have to pay them overtime if they work over 40 hours, and all the other aspects of workplace protections that exist for employees will then be extended to that individual. That's the California test, which is currently in place down there. It's the ABC test. Look out for that. In the extreme, Congress may try to adopt that as a law under the Fair Labor Standards Act, as well as the various laws, agencies, the Internal Revenue Code, for example. At a minimum, you'll see the Department of Labor proposing regulations in the future and then finalizing these rules into its regulations. So it'll become the effective law of the land until the next administration comes along. Number 5, the Trump NLRB actually, I think, was quite modest in looking at overtime exemption issues. They didn't really change it too much other than to raise significantly the salary requirement for under the salary basis test. So currently, somebody would need to be paid a salary of $47,476 in order to be considered exempt under the Fair Labor Standards Act. I think you could expect that number to increase significantly. It's very clear, and has been clear for a long time by labor, by employee advocates, by Democrats who have spoken on the subject, that they really believe that that a for white collar exemptions, for bona fide administrative or executive or professional exemptions, individual salary has to be way up there, really approaching 6 figures. I would not be surprised if this number was doubled to more than doubled and enters 6-figure categories. And again, that can be pursued through amending the Fair Labor Standards Act to create that exemption, or through regulation. The Democrats with the majority may feel the need to strike while the iron's hot when they have the majority and try to change the law itself. And if failing that, at least on an interim basis, you'll see the Department of Labor creating regulations in that regard. And also you'll see this reference to wage theft laws, which is popularized on the West Coast. Seattle has a wage theft law. I'm not sure if the state of Washington does. I think it does, actually. It doesn't come into play very often, but this would require employers to provide detailed pay statements while expanding the penalties for willful instances of wage theft and falsifying records and whatnot. This has been it's easy to put a law out there, put on a platform that you're opposed to wage theft. There's not much meaning to it. Frankly, I've not seen much in the way of prosecution of this or civil lawsuits in the city of Seattle on wage theft, but it's a popular platform item. And it is something that, for example, the new Secretary of Labor adopted for the city of Boston. And so I imagine that he will be having a similar initiative with the Department of Labor on the federal level. Okay. We're going to have a very, very brief intermission, and given in the interest of time, that was it. Number 6, the use of project labor agreements. And oops, I'm sorry, I just inadvertently skipped that. Let me talk about this, because this is, there we go. Everybody here on this call, I believe, knows what a PLA is, or Community Workforce Agreement. I think I mentioned the Community Workforce Agreement on the State Route 520 project through DOT as being with the case brought by AGC. But for everybody's benefit, again, it's a refresher. These are pre-hire bargaining agreements, or agreements with unions specifying terms and conditions of employment for public works and some private projects. It's in the state of Washington by governor decree years ago. It is the state policy to promote PLAs on public works projects in the state of Washington. It's not by law required, but the governor very clearly set forth the standard in strongly encouraging all Washington-based public projects to, be with project labor agreements. Obama, back in soon after he took over, signed an executive order mandating the use of PLAs on federal projects totaling $25 million or more. Okay. Now, fast forward then to 4 years under Trump, and the Obama executive order, even though it's still in effect, was not really used by Trump. And I believe there was only 1 or 2 federal projects that had a PLA requirement in them. Okay, now the pendulum is swinging back, and we have a Democratic president who might even be more beholden to labor, than organized labor, than President Obama was. And he's committed to expanding the PLA mandate. We already read his platform saying that he wants it on all federal projects. And if he does not achieve that, I think you would see a reduction in that $25 million threshold. So that would expand the number of projects that would have the PLA mandate in that. I can't think of a better source for learning more about PLAs and what your options are than ABC. And so here's a link to the ABC website regarding project labor agreements. This is something that is really in the forefront of merit shop consciousness out there. And I think, unfortunately, what you're going to see, not for state projects, because we've already been living under the Inslee commitment to expand the use of PLAs in the state of Washington for state projects. But if you're going to be working on any federal projects, then you're going to be now faced with the PLA requirement. So start planning if that is a part of your business model. Okay, number 7. The president wants to limit the scope of employment agreements. I'm not going to dwell on this too much, but labor and employee advocates and the plaintiff bar do not like non-compete agreements. They're effectively prohibited in California, and since that's the source of many of President and his advisors' inspiration for changes in the workplace, it's likely that you're going to see reintroduced in Congress legislation to prohibit non-compete agreements except to prohibit trade secret theft, if you will. They don't like class action waivers. You're going to see federal law proposed in that regard, as well as prohibiting the use of mandatory arbitration clauses. Section 8F contracts, this is number 8, and this is a little bit longer term. The Trump board pushed through a regulation, the NLRB that is, pushed through a regulation that changed the standard for establishing a Section 9A relationship. Section 9A is the typical relationship between employers and unions, where employers must demonstrate that they have a majority of employees interested in belonging to the union, or at least being a union shop, if you will. And then that can garner the union a secret ballot election if the employer doesn't voluntarily recognize them. So most labor agreements out there are 9A agreements. They're just created because the NLRB has certified the bargaining unit. But in the construction industry, under Section 8F of the National Labor Relations Act, you can have what's called an 8F agreement, which is for certain projects or based on the seasonality, if you will, of some construction work. An employer and a union can sign a contract without the required showing or majority showing of interest by employees. The employer can, once the contract ends, can unilaterally basically say, I'm not going to recognize the union anymore. And these are sort of like glorified, if you will, PLAs, although there are some 8F agreements that have been in place for decades. I just was reviewing one last year that had been in place for about 25 years. Just kept being renewed, and then the employer decided didn't want to do it anymore, and they could. Now, what happens though is that many 8F contracts, the union goes in and the employers agree just to say, okay, we're going to call this a 9A contract now. Now you can only get rid of us through decert. For the union, it creates stability. The employees can't get rid of them. The employer can't get rid of them as easily. But there's been no showing of interest. So the NLRB put forth regulations requiring that before a construction employer and union enter into an 8F, or excuse me, a 9A agreement, there has to be a proof that the employees represent a majority of the workers, which oftentimes is not possible because the majority of workers are not interested in having the union. So on this one in particular, I think that because it's a regulation, it's going to be harder for the Biden NLRB to reverse it, but they will need to propose regulations basically rescinding that. And given construction trades are all over the Biden administration, I expect that that will happen. So we'll go back to the old standard based on an NLRB case that would allow employers and unions just to write a contract saying now we're 9A. And it makes it much, much more difficult for employees to remove the union in that kind of situation. Okay. Number 9, expect systematic rollback of Trump-era NLRB initiatives through regulation, through case law. And I'm not going to, I've already mentioned some of these, the joint employer case, the McDonald's case that's currently being litigated, where the Trump NLRB was raising the white flag on McDonald's and saying that no, there's no joint employer status. I think that effort is going to be thrown off, and the new NLRB is going to revert to its position that McDonald's Corporation and similar corporations like that are joint employers. The Boeing case, under the Boeing case, employer policies were given the green light in many instances, and the board created a new test for determining when policies violate employee Section 7 rights to engage in concerted activities. Union, non-union, doesn't matter. The case applies to all employers, and many employee advocates hated that, union folks in particular, because many policies that the Obama board considered unlawful now were given the blessing by the NLRB. There is a new regulation in place that the Trump board put in that made it easier for employees to get rid of unions after the employer and the union voluntarily recognized. The employer voluntarily recognized the union, and so in that case, that regulation will probably be rolled back as well. There is a current case law regarding when employers can stop deducting dues automatically. Most automatic dues deduction provisions in contracts Many of them at least have those provisions, and under the Trump board, once the contract expires, those provisions are no longer enforceable, and the employer can stop deducting dues, which puts an economic squeeze on unions. Unions hate that, and so they're going to advocate for a return to the Obama case law, which said that the employer needed to negotiate the discontinuance of those automatic dues prior to stopping the dues. Okay, you'll probably end up having to allow employees to use your email system as well under the old law, as well as I'm guessing there will be an effort to go back to the micro unit decision, especially healthcare, by the Obama board, which made it much easier for unions to organize workplaces by allowing unions to go and organize a small little sector of the workplace or job class rather than other employees who share a community of interest. It allowed unions to get their foot in the door. Trump board said, no, you have to negotiate, or excuse me, you have to organize everybody who has a community of interest. So a larger group makes it harder for a union to win an election. Unions hated that. So guess what? The unions are in control now. And I'm sure the NLRB is going to go back to the specialty healthcare standard that President Obama's NLRB put forth. All right, I made reference to the PRO Act here, and I'm going to be wrapping up in about 2 minutes here, but the PRO Act is really significant because this was a law that was proposed and introduced in the House in early 2020, went nowhere in the Senate because of the Republican majority. This law would change federal labor law in many respects. It would create financial penalties against employers who get in the way of workers' organizing efforts. So unfair labor practice charges that succeed would carry with it not only a cease and desist by the NLRB, but also financial penalty as well. It would require employers and unions negotiating first contracts to submit their disagreement to binding arbitration, interest arbitration, if there's no agreement reached within 90 days. Even in simple cases, it takes oftentimes a year to negotiate a contract. And this kind of provision under the PRO Act would basically encourage unions to stall, drag their feet, not get to an agreement, and then let an arbitrator give them what they couldn't achieve at the bargaining table. It is the law of the land for uniformed personnel and public contracts in this state and many other states, because police officers, firefighters, and whomever, as well as frankly most public sector workers, but the uniformed personnel cannot strike. It would jeopardize public safety, and so interest arbitration is a requirement for public sector. Now Biden wants to make it a requirement for all private negotiations of first contracts. You no longer be able to meet with employees in so-called captive audience meetings to tell them unions are not necessarily the way to go. The PRO Act would prevent permanent replacements in a strike situation, which completely tips the balance and strikes in favor of unions if the employer has no economic weapon to combat a strike with. The joint employer rule would be codified into law. We've talked about that one already. You'd be going back to the good old card check law, right? So if there's an election petition filed, the union wants an election. Oh, guess what? The union is losing the election, so they file unfair labor practice charge against the employer, alleging, oh, of course we're losing the election because you sent a bad email to somebody, or you look sideways at somebody, and that violates the law. If the NLRB buys into that, then and issues a complaint saying there is an unfair labor practice charge, then in that case, the rerun election would be conducted through card check. And it's the old EFCA days, if you will. And there are many bad elements associated with card checks we can go into for an hour. But I'm afraid that that is now going to be resurrected as just one of the provisions of the PRO Act. PRO Act would also require employers to basically report whatever payouts they made to third-party consultants who work behind the scenes to help them run organizing campaigns. For all elements of the PRO Act, there's some good sources to look at. U.S. Chamber website has sort of what their take on it is. You can imagine what it is, as well as you could read the law itself. It is a big deal. And given the makeup of the Senate and the House and the White House, it is a serious threat. It's something that you really should be monitoring. And then separate from that, as I said earlier, you're going to see laws that are proposed to ban right to work laws, but I have a feeling that that's not going to go anywhere because there's some Democratic members of the Senate in right to work states. And they would be feeling the heat from all sides. So I think that it's aspirational, but I don't think that law is going to go anywhere. So I've gone way over. I apologize, but there was a lot to cover. Hopefully I'm not leaving you with too pessimistic of an outlook. However, that's all I have to say. I appreciate everybody's attention, and I think there should be time for questions right now, hopefully. And I can go past 8:30, so I could stick around if we have a lot of questions. Otherwise, thanks everybody for being here this morning.
Thank you so much, Matt. I know we do have some questions, so we're going to switch over from the webinar portion of this and move into the question and answer part. So I think Suzanne Schmidt, I believe, has a question. So I'm going to pick on her, and as this kind of loads up, I'll ask her to chime in and ask her question. But thank you so much, Matt. That was so much information and really helpful and daunting, I would say.
So actually, I didn't. I was just trying to unmute myself. But I mean, it's, yeah, good information. Thank you so much for presenting it to us. I mean, I shouldn't say it's information that we need to know, and we need to keep our eye on. And you know, thank you for presenting that. So.
Does anyone else have any questions?
Thanks, Suzanne.
Yeah.
I mean, I think, Matt, one question that I have just after listening to you, you in the beginning, we're talking about all of the regulations that the Biden administration is going to be able to freeze or change. And do we have any power in preventing that? I mean, what do we do now?
Well, when it comes to regulations, the process is that the agency will propose regulations. So for example, if I would expect the Department of Labor will make a push to craft and put out a proposed regulation adopting the ABC test for purposes of determining independent contractor status under the Labor Standards Act. And when they put out proposed regulations, then there is an extended comment period, and it's often extended. So the initial comment periods usually are about 3 months long, and if this proposal is put out early in the Biden term, they'll probably extend it. And all advocates on all sides can weigh in and provide comments. You get law firms representing management, you get the AFL-CIO, you get employee advocates. ABC would be putting comments in, AGC would be putting comments in. And then the final rules are meant to sort of reflect those comments. And the agency in that case has to respond to those comments. Here's why we put out this rule. Here's why the comments over here didn't make the cut because of XYZ reasons. Here are the comments from so-and-so that made sense to us, and so we incorporated those in the regulations. So that's when that's really the only, at this stage, the only real influence you would have. I mean, you can lobby, right? You can lobby, and on the national level, the national ABC and AGC and frankly other groups, U.S. Chamber, NAM, they'll be lobbying certain legislators, senators in particular, and some House members to try to influence or encourage DOL not to go down a certain path. But given where we are now, and given there's 4 long years of the Biden term, I don't think that those any pleas, if you will, or efforts on the part of certain senators or Congress folks are really going to hold much sway. We'll have to see in 2 years. I mean, if there is a clear change in 2 years, swinging back to the right, then there will be real influence to put the kibosh on any of those regulations.
Yeah, I was just going to add in, we're in the same situation really here in the state of Washington, the same thing, because we have the Democratic governor, House and Senate, and we go through the same thing with the public hearings for rulemaking. But I mean, we can absolutely be involved, but it's really difficult to get our, our point across if if the other side is pushing hard. So that's, I'm just going to jump in here really quick to say that's why, honestly, the election in 2022, whether it's at the state level or the federal level, is hugely important. Otherwise, we have 4 years of this.
Right.
Yeah. And I think that's, Matt, you didn't leave a very light presentation on Tuesday.
Well,
yeah. It's the reality. So if anyone else,
but let me say this, I just want to add one thing. I mean, and again, I'm not overly familiar with the ins and outs of what goes on in DC, but when President Obama took over, there was a Democratic majority in the House, Democratic majority in the Senate, and he ran on a platform of getting EFCA passed, right? Employee Free Choice Act. And there was a lot of pessimism in your community, in the circles I fly in, that EFCA now is going to eliminate secret ballot union elections and require employers to recognize unions merely on the basis that somebody signed an authorization card. And we all know the problems and what can go into reasons why somebody signs an authorization card. And they're not all because they want the union. It could be they want to just get somebody off their back. So that was a problem. But EFCA never became law. I mean, they never got their act together. And they got sidetracked by the ACA, right? The Affordable Care Act. That sort of dominated the discussion, and EFCA got lost in the mix. And then boom, 2 years goes by, and then there's a swing in the Senate, I believe, to the Republicans. So that made EFCA a dead issue. So I think that there are people who, so that could happen. On the other hand, memories are long, and the labor community still knows what happened with EFCA, and they may want to, as I said earlier, strike while the iron's hot, get this stuff passed while they can, because there are no assurances in 2 years that, there'll be the votes there to pass that law.
Well, that's encouraging. Does anyone else have any questions that they'd like to ask this morning?
Yeah, this is Bill Hubanks. I just had one question about the PRO Act. And just, I'm an attorney as well, and one of the big things I have problems with is disclosing who you're speaking to when you're talking about behind the scenes organizations. Matt, I was just wondering, is there anything maybe by other legal organizations? I know the ABA initially opposed this, or at least that portion of it.
Right.
The other organizations that typically have more left-leaning Democratic support behind them that have voiced opposition to the PRO Act.
And I think, Bill, you're referring specifically to the one provision of the PRO Act dealing with the persuader rule, right? And that's the rule for everybody's benefit that would require employers to disclose on financial disclosure forms that are filed with the feds and are public knowledge, the amount they would need to disclose who they're paying to advise them, and the advisors, the so-called persuaders, and I won't go into why they're called persuaders, but that's the term of art here. The persuaders would need to file forms in financial disclosure in terms of not only the work they do for, XYZ company and fighting the union, but they would need to disclose all of their clients. That was the original persuader rule put out by the Obama board. And Bill is absolutely right. I think that the death knell for that effort was that the ABA got involved and said there is a thing called attorney-client privilege here, and the persuader rule that Obama's the Obama Department of Labor was pushing was completely kicking attorney-client privilege into the curb. So that's a pretty potent lobbying group, and that rule just never went anywhere. And that's one of the problems with the PRO Act. So yeah, I mean, you're going to still have the ABA jumping all over it unless they carve out attorneys from that rule, in which case then the ABA will be neutral and there will still be a provision of it. I'm not aware of any left-leaning organizations that would be aligned with employers on this. I just don't, because the unions, again, for those who don't know, they have their own disclosure requirements. They have to file financial forms called LM2s that inform the world who they're paying, what law firms they're paying money to and whatnot. Those law firms, I don't believe, need to disclose the work they do for the union. So the union's already subject to part of what the PRO Act would require everybody to do. So they're not going to be supportive of any, less obligation on the part of employers and persuaders to submit than or to file than the union's already subject to. So I think it's going to be the employer community who will be carrying that banner against that particular provision, but they'll be fighting the entire law as well.
All right. Well, Matt, thank you so much for joining us this morning and for all of this information. And thank you to our members and everyone who joined us this morning. If you have any further questions or need to follow up with me, feel free. My email is sophia@abcwestwa.org. And again, thank you all so much. And thank you, Matt.
Glad I could be here and good talking to everybody.
Yep.
Thank you.
Yeah. Thank you, Matt.